The courtroom didn't erupt. It went quiet. Not the comfortable quiet of routine procedure. Not the polite silence before a ruling. This was the kind of quiet that lands suddenly. The kind that makes people shift in their seats without knowing why. The kind that tells you something has just changed, even if no one has said it out loud yet. Before we continue, please hit the like button, subscribe to the channel, and turn on the notification bell for updates. For weeks, this case had been framed as something familiar. Another chapter in a long war between a prince and the press. Another attempt to correct the past. Another effort to drag decades-old grievances into the light and force accountability. That's how many people thought this would unfold. Slowly, predictably, almost mechanically. But something about this moment felt different. Because for the first time, the spotlight wasn't on the tabloids. It wasn't on the headlines. It wasn't even on Prince Harry. It was on the judge, and more specifically, on what the judge wasn't doing. He wasn't nodding along. He wasn't signaling agreement. He wasn't offering the subtle cues lawyers look for when they sense the room is leaning their way. Instead, there was distance, a pause, a kind of measured restraint that, in a courtroom, can be far more dangerous than open hostility. Here's the uncomfortable question no one wanted to ask out loud at that moment. What happens when a case built on moral certainty starts colliding with judicial skepticism? Because this trial was never just about whether unlawful information gathering happened decades ago. It was about credibility, about burden, about how far narrative power can carry you once you're no longer speaking to the public, but to the law. And courts, unlike audiences, don't applaud conviction. They interrogate it. Prince Harry arrived in London's High Court with something few claimants ever bring with them. A global audience that already knows his story. Years of interviews. A best-selling memoir. Public sympathy carefully cultivated through openness, vulnerability, and pain. For a long time, that approach worked. It reshaped how people saw him. It reframed old scandals. It challenged institutions that had rarely been forced to answer back. But a courtroom is not a confessional. And it's not a documentary. In this room, feelings don't carry weight unless they are tethered to proof. Memory doesn't become evidence just because it's sincere. And accusations, especially severe ones, don't land simply because the accused is unpopular. That's the collision this case is quietly moving toward. On paper, the claims sound straightforward. Harry accuses the publisher of the Daily Mail and the Mail on Sunday of unlawful information gathering, of commissioning or carrying out illegal activities to obtain private information used in articles published years, sometimes decades, ago. He says those actions violated his privacy, that they crossed legal lines, that they caused real harm. The publisher, just as firmly, says no. No unlawful activity, no illegal sourcing, no hidden misconduct. They call the accusations preposterous, without foundation. They argue that many of the articles in question were published 20 or more years ago and were never formally challenged at the time. They say their journalism relied on legitimate sources and standard reporting practices. Two narratives, two versions of history, two completely different interpretations of the same past. So far, nothing unusual. But then something happened that shifted the tone. Harry's legal team didn't just challenge the publisher's defense. They attacked it. They labeled elements of the defense as fraudulent. Not mistaken, not flawed. Fraudulent. That word matters. In a courtroom, words are not just language. They are weapons. And accusing the opposing side, implicitly or explicitly, of fraud is not a rhetorical flourish. It's a serious allegation that raises the stakes immediately. It tells the judge, this isn't just a disagreement. This is deception. And once that accusation is made, the court doesn't just examine the defendant. It examines the accuser too. That's when the atmosphere began to change. Because judges don't respond well to overreach. They don't like being cornered by absolutes. And they are deeply wary of claims that escalate faster than the evidence can support. This trial is scheduled to run for more than 2 months, ending on March 26th. That alone tells you something. Courts don't allocate that kind of time unless they expect complexity, layers, disputes that won't resolve cleanly. And when a case stretches that long, every early impression matters. Every inconsistency lingers. Every moment of impatience compounds. The ruling won't come immediately after the trial ends. Judge Matthew Nicklin is expected to deliver his decision at a later date. That delay isn't procedural trivia. It's a warning sign. It means the court is going to sit with this, dissect it, revisit testimony, re-examine claims line by line. And that's where things get uncomfortable for Harry. Because much of this case leans heavily on memory, on patterns inferred from old practices, on assumptions about how stories must have been sourced because of how intrusive they felt. That approach may resonate emotionally, but legally, it's fragile. Courts don't punish what feels wrong. They punish what can be proven. And proving unlawful information gathering from decades ago is notoriously difficult. Records disappear. Witnesses fade. Industry practices evolve. What seems shocking then may be explainable now. Or worse, ambiguous. This is where the story stops being about the press and starts being about strategy. Was this case built to win in court? Or was it built to win in the court of public opinion? Those two goals don't always align. In fact, they often conflict. Public narratives thrive on clarity. Heroes and villains. Victims and aggressors. Courts, on the other hand, live in gray zones. They demand precision. They punish exaggeration. They notice when language outpaces evidence. And when Harry took the stand, that tension became impossible to ignore. His testimony was confident, at times deeply personal. He spoke about how invasive coverage affected him, how it shaped his perception of the press, how it compounded grief and trauma. Those moments landed emotionally. You could feel the weight of lived experience behind them. But then came the questions. Specific ones. Narrow ones. Questions about dates. About sourcing. About how he knew what he claimed to know. About whether certain conclusions were based on evidence or assumption. And this is where something subtle happened. The judge didn't challenge Harry aggressively. He didn't dismiss him. He didn't cut him off in frustration. Instead, he listened. Carefully. Almost clinically. And that kind of listening can be dangerous because it leaves nowhere to hide. When answers drift. When certainty softens. When recollections blur. None of that looks dramatic. There are no gasps. No raised voices. Just notes being taken. Pauses extending a second longer than usual. Follow-up questions that quietly expose gaps. For viewers following this case from afar, it might all seem underwhelming. Legal. Technical. Slow. But for those inside the courtroom, it's the kind of slow that tightens over time. Because once a judge starts questioning the foundation of a claim, everything built on top of it becomes unstable. And then there's the issue no one likes to talk about openly: credibility asymmetry. Prince Harry is not a neutral witness. He is a claimant with a history. A public figure whose relationship with the press is openly hostile. That doesn't disqualify him from seeking justice, but it does mean the court scrutinizes his claims through a different lens. Bias isn't assumed, but perspective is acknowledged. And when Harry's legal team escalated their language, when they suggested fraud, they invited the court to look even harder, to ask not just whether wrongdoing occurred, but whether the accusation itself was responsibly made. That's where judicial patience starts to matter. Judges have long memories within a trial. They remember tone. They remember posture. They remember moments when arguments felt solid and moments when they felt forced. This is not a case that will turn on a single document or a single witness. It's going to turn on accumulation, on whether the overall picture holds together under sustained scrutiny. And right now, there are signs, quiet ones, that the picture is starting to fray. None of this means Harry will lose. None of this means the publisher will win. But it does mean something important. The momentum Harry may have expected is not guaranteed. That realization doesn't arrive with a bang. It arrives with a pause, with a judge leaning back slightly, with a question asked twice because the first answer didn't quite land. It arrives in silence. And that silence is what makes this moment so dangerous. Because once a court stops leaning toward you, getting it back is far harder than losing public favor. Courts don't respond to clarification tours. They don't watch follow-up interviews. They don't care how compelling your broader story is. They care about what's in front of them. Right now, on the record. As this trial stretches on, every day adds weight. Every exchange leaves residue. And every strategic decision, especially the aggressive ones, will be re-evaluated in hindsight. The question hanging over this case isn't whether the press behaved badly years ago. It's whether Harry's case can withstand the kind of scrutiny that strips away narrative and leaves only structure behind. Because in a courtroom, once the structure cracks, no amount of conviction can hold it up. And just as the room went quiet, the judge prepared to ask something else, something that would force everyone to confront how solid this case really was. Was this the case Harry thought he was winning? That was the question hanging in the air as the judge prepared to speak again. Not dramatically, not with visible irritation, but with that same measured calm that had already begun to unsettle the room. It's a strange thing, watching confidence meet resistance without either side raising its voice. Stranger still when the resistance doesn't announce itself. It just waits. Harry's team had come in believing momentum was on their side. You could feel it in the posture, in the pacing, in the way arguments were delivered as if they were already halfway accepted. This wasn't meant to be a fragile case. It was meant to feel overdue, inevitable, almost corrective. Because from Harry's perspective, this lawsuit wasn't a gamble. It was a reckoning. For years, he had spoken about the British press as if it were a single, malignant force. One machine, many faces, same methods. The details varied, but the conclusion was always the same. Intrusion wasn't accidental, and it wasn't isolated. It was systemic, coordinated, and, in his view, unlawful. So when this case finally reached the High Court, there was an expectation, maybe unspoken, but unmistakable, that the legal system would at last validate what he had been saying all along. Not just emotionally. Legally, that expectation shaped everything. From the outset, Harry's claim framed the publisher not as a flawed institution that made questionable choices, but as one that crossed hard legal lines. The accusation wasn't simply unethical behavior. It was criminal adjacent, unlawful information gathering. Activities carried out or commissioned to obtain private details that should never have been accessible. And the confidence behind that framing mattered. Because courts notice when a claimant isn't hedging, when language is definitive, when the tone suggests certainty rather than inquiry. That can be powerful or perilous, depending on what follows. The publisher's response was almost deliberately dull by comparison. No emotional counterattack. No outrage. Just denial. Flat, procedural, and, at times, almost boring. They argued their journalists didn't commission illegal activity, that stories were sourced legitimately, that many of the articles being cited were decades old and never challenged when they ran. It wasn't a thrilling defense. It was a patient one. And patience, in court, can be a strategy. The problem for Harry is that his case wasn't designed to unfold slowly. It was designed to feel obvious, to build toward a conclusion that felt morally self-evident even before the evidence was fully examined. But courts don't reward obviousness. They reward rigor. As the early days of testimony unfolded, that mismatch started to show. Harry spoke with conviction about how invasive the coverage felt, how it seemed impossible that journalists could have known certain details without crossing lines. That logic makes sense on a human level. When something feels too precise, too personal, too timely, it's natural to assume misconduct. But assumption is not proof. And the judge's questions reflected that distinction again and again. Not hostile questions, clarifying ones. Questions that forced a separation between what Harry believed happened and what could be demonstrated. At one point, the questioning circled around how Harry knew certain information had been obtained unlawfully. The answer, in essence, leaned on inference, on patterns, on a broader understanding of tabloid behavior during that era. The judge listened, then asked again, slightly differently. And that's when the tension sharpened. Because repeating a question isn't always about confusion. Sometimes it's about testing whether there's more beneath the surface, whether the first answer was incomplete, or whether there simply isn't another one. This is where cases quietly start to pivot. Not with a dramatic collapse, not with an objection sustained, but with a realization. The foundation may not be as solid as it felt from the outside. Harry's legal team tried to reinforce that foundation by widening the lens, by contextualizing the press environment of the time, by invoking other scandals, other revelations, other cases where unlawful practices were later proven. The implication was clear. If it happened elsewhere, why not here? It's a compelling argument rhetorically. Historically, it has weight. Legally, it's risky. Because courts don't convict by association. They don't punish one publisher for the sins of another. And they are deeply cautious about importing conclusions from unrelated cases, no matter how similar they may appear. Judge Nicklin's role isn't to rule on the culture of tabloids in the early 2000s. It's to rule on whether this publisher, in these instances, crossed the legal threshold. That distinction sounds technical, but it changes everything. It narrows the field. It raises the bar. And it makes broad claims feel suddenly vulnerable. You could sense that vulnerability creeping in as the exchanges continued. Not because Harry faltered emotionally, he didn't, but because the courtroom began to feel less receptive to narrative shortcuts. At one point, the defense emphasized the age of the articles, 20 years or more, not as an excuse, but as a reality. Memories degrade. Records vanish. Editorial processes evolve. What was common practice then may not be now. And vice versa. The implication wasn't that wrongdoing couldn't have occurred. It was that proving it now would be exceptionally difficult. That's when Harry's team escalated. Labeling aspects of the defense as fraudulent wasn't just about strengthening their case. It was about forcing urgency, forcing the court to choose between two stark options. Either the publisher was lying or the entire defense collapsed. High-risk move, high reward if it landed. But it also placed a spotlight on the accusers themselves. Because once fraud is alleged, the court has to ask, on what basis? Fraud isn't inferred lightly. It requires intent, deception, evidence that something was knowingly misrepresented. And the judge's reaction, or lack of visible reaction, said more than any immediate rebuke could have. No interruption, no warning, just continued questioning, continued note-taking. That's when the sense of inevitability Harry's side seemed to carry began to evaporate. Slowly, almost imperceptibly. This wasn't the courtroom of public opinion, where intensity often substitutes for precision. This was a room where every assertion invited scrutiny, especially the most confident ones. And there's another layer here that complicates everything. Harry's own public record, his memoir, his interviews, his long-standing critique of the press. All of that exists outside the courtroom, but it doesn't disappear when he walks inside. Judges don't ignore context. They just don't let it override evidence. When someone has been vocal for years about a perceived injustice, courts have to consider whether current claims are shaped by that history. Again, not to discredit automatically, but to understand perspective. That's a delicate balance, and it's one that places enormous pressure on consistency. Any contradiction, any overstatement, any moment where certainty outpaces substantiation becomes magnified. Watching this unfold, it's hard not to sense that Harry's team expected resistance, but not this kind. They anticipated pushback from the defense, not sustained skepticism from the bench. And that changes how a case feels. When the judge starts asking the kinds of questions that suggest he's mapping weaknesses rather than simply clarifying facts, lawyers notice. They adjust. Sometimes too late. This case, which began with the energy of a long-awaited confrontation, was beginning to feel like something else entirely. A test. Not of the press. Of proof. Not of ethics. Of restraint. And beneath it all, a quieter question started to surface, one no one had voiced yet, but everyone could sense forming. If the court isn't convinced by the strongest version of this argument, what happens next? Because trials don't just end with verdicts. They end with consequences. For credibility. For future cases. For how similar claims will be received down the line. That's the weight Judge Nicklin carries as he listens, as he pauses, as he asks the same question in slightly different ways. And as the day drew on, it became increasingly clear that the judge was no longer just hearing Harry's story. He was testing it. So why use that word? Why escalate the language when the room was already tightening, when the judge was already leaning forward, listening more than speaking, weighing rather than reacting? Fraud. It's a word that doesn't echo softly in a courtroom. It doesn't drift. It lands. Hard. And once it's on the record, it doesn't disappear just because the speaker moves on. Harry's legal team used it deliberately. That much was clear. This wasn't a slip. It wasn't heat-of-the-moment phrasing. It was a strategic choice, made in full view of the bench, and it immediately altered the geometry of the case. Because accusing the publisher of fraud didn't just challenge their defense. It challenged their integrity. It suggested not merely that the journalists were wrong, or careless, or aggressive, but that they were knowingly misleading the court. That they were constructing a defense on false premises. That they were, in effect, lying. And courts are deeply sensitive to that accusation. Here's the thing most viewers never fully appreciate. Judges expect disagreement. They expect sharp argument. They even expect exaggeration at the edges. But fraud is different. Fraud implies intent, conscious deception, a line crossed with eyes open. Once you allege that, the court has. From Nicklon's perspective, accusing a party of fraud is not a flourish. It's an assertion that raises the evidentiary bar significantly. And once raised, it demands a response, not necessarily immediately, but eventually. Judges don't forget those moments. They note them. They return to them. They ask whether the claim was proportionate, supported, necessary. And proportion matters in Nicklon's courtroom. One of the striking aspects of his questioning was how often it returned to first principles. How do we know this? What supports that conclusion? What alternative explanations exist? Have they been ruled out? These are not aggressive questions. They're foundational ones. But they can be destabilizing if a case relies heavily on cumulative inference rather than direct proof. At times, it felt as though Nicklon was testing not just the facts, but the discipline of the argument itself. Whether it stayed within its own logical boundaries or spilled outward into assumption. That's where Harry's team seemed most exposed. Their case gained strength from breadth, from the idea that what happened to Harry was part of a larger pattern of behavior. Nicklon's approach insists on depth instead, on drilling down until only what can be shown remains. Those two approaches don't naturally align, and the longer the trial continues, the more that misalignment matters. Another thing worth noting is Nicklon's apparent comfort with complexity. Some judges seek clarity early. They want to simplify. Nicklon seems content to let complexity breathe, to allow contradictions to sit unresolved while he gathers more information. That's unnerving for litigants who expect momentum to build steadily in their favor. Because in Nicklon's courtroom, momentum is not linear. It's cumulative. Every answer adds weight. Every evasion adds friction. Every confident assertion without clear support adds tension. Harry's team may have underestimated how much that cumulative effect would shape the outcome. They appear to have anticipated a more overt judicial engagement, a sense of alignment or resistance that could be read and responded to. Instead, they are faced with a judge who reveals little and records everything. That opacity makes strategic adjustment difficult. Do you escalate? Do you pull back? Do you clarify? Do you wait? There are no obvious signals, and that uncertainty is amplified by the length of the trial. 2 months is a long time to operate without clear feedback from the bench. It invites overcorrection. It tempts lawyers to press harder, to fill silence with emphasis. But silence doesn't always need filling. Sometimes, it's doing the work for the court. As this chapter of the trial unfolded, one thing became increasingly clear. Judge Nicklon is not approaching this case as a referendum on press behavior or royal grievance. He's approaching it as a technical question of law, evidence, and proportionality. That may sound obvious, but in a case saturated with public emotion and historical baggage, it's anything but. And it places Harry in a precarious position. Because if the judge ultimately decides that the case was argued with more conviction than precision, that decision won't be framed as a moral judgment. It will be framed as a legal one. Those are harder to contest. As the questioning continued, and as the judge's notes grew longer, the sense that this case was slipping out of the realm of narrative and into the realm of scrutiny became impossible to ignore. The next phase would test not just what Harry believes happened, but how well those beliefs withstand the kind of examination that leaves nothing implicit. And the questions coming next were already sharpening. How much does time change a case? That question doesn't announce itself loudly in court. It doesn't arrive with an objection or a raised eyebrow. It seeps in, slowly, almost politely. And once it's there, it touches everything. Because this case isn't unfolding in the present tense. It's reaching backward, 20 years, sometimes more, asking a court in 2026 to reconstruct intentions, methods, and decisions made in a very different media landscape. A landscape before smartphones, before social media, before leaks were time-stamped and archived automatically. Time, in other words, is not a neutral backdrop here. It's an active force. And as proceedings moved deeper into the evidentiary phase, that force began to press down on Harry's case in ways that were difficult to counter without sounding speculative. This is the part of trials that rarely makes headlines. It's not dramatic. It's not emotional. But it's often decisive. Because courts don't just ask what happened. They ask how well we can know what happened now. Memory becomes central here, and memory is unreliable even when it's honest. Harry's recollections are sincere. There's no real dispute about that. He remembers how it felt to read certain articles, how invasive they seemed, how specific details landed like violations rather than reporting. Those memories matter to him. They shape his narrative. They explain why he believes unlawful activity must have occurred. But belief and proof don't age the same way. Judges are acutely aware of how memory evolves over time, how it absorbs later information, how it reshapes itself around stories we tell ourselves repeatedly, how public narratives, interviews, books, documentaries can subtly reinforce certain interpretations while eroding others. This doesn't mean memory is false. It means memory is fluid, and fluidity is a problem in court. When testimony relies heavily on recollection rather than contemporaneous records, judges instinctively look for anchors. Documents, emails, financial trails, anything that existed at the time, not reconstructed afterward. In this case, many of those anchors are missing, not because someone destroyed them, necessarily, but because 2 decades is a long time in any industry, especially one that moved fast and kept records inconsistently in the early 2000s. Newsrooms didn't archive internal communications the way they do now. Freelancers were paid in ways that are difficult to trace retrospectively. Sources came and went. Editors rotated. Systems changed. That doesn't absolve anyone of wrongdoing, but it complicates proof. As the judge navigated this terrain, his questions increasingly reflected an awareness of that complication, not as an excuse, but as a reality check. When Harry's team suggested that certain practices must have been unlawful because of how intrusive the resulting articles were, the judge's attention shifted to alternative explanations. Could those details have come from insiders? From acquaintances? From leaks unrelated to illegal methods? These aren't comfortable questions. They challenge the neatness of the narrative. But courts thrive on discomfort. It's how they avoid shortcuts. One particularly telling moment came when discussion turned to whether the absence of direct evidence should itself be interpreted as evidence of concealment. The implication was subtle, that unlawful practices are, by nature, hidden, and therefore the lack of record supports rather than undermines the claim. It's an understandable argument. It's also one courts treat with caution, because if absence of evidence becomes evidence, the standard of proof collapses. Anything can be inferred. Any defense can be dismissed as conveniently undocumented. Judges know this. They guard against it. Nicklin didn't reject the argument outright. He didn't need to. Instead, he returned again to specificity, to whether there was anything concrete, anything at all, tying a particular article to a particular unlawful act. The answer, again, was complicated. Much of the case rests on probability rather than demonstration. On the idea that certain stories could not plausibly have been sourced legally given what was known publicly at the time. Probability has persuasive power, but in law, it's not dispositive. The burden remains on the claimant, and that burden grows heavier as time stretches backward. Another layer of complexity here is technological context. The early 2000s were a transitional period for media. Digital records were partial. Communication methods were inconsistent. Some practices that would raise alarms today were poorly regulated or understood then. That doesn't make them lawful, but it does make reconstructing them harder. Judges don't judge past actions by present standards, at least not automatically. They look at what rules applied at the time. What was known? What was enforceable? Harry's case, by contrast, often frames the past through a modern moral lens. That lens is compelling. It aligns with contemporary understandings of privacy and consent. But legal standards lag moral ones. Always have. And when courts adjudicate historical claims, that lag becomes a fault line. This is where the emotional power of Harry's story runs into structural resistance. From his perspective, the harm is continuous. The invasion doesn't feel less invasive because it happened long ago. The impact doesn't diminish with time. If anything, it compounds. But the law doesn't process harm cumulatively in the same way. It asks when the harm occurred, how it was known, whether it was actionable at the time, whether remedies were sought then. The publisher has leaned into that temporal gap, pointing out that many of the articles were not formally challenged when published. That fact doesn't prove they were lawful, but it does raise questions. Why now? Why this moment? Why this framing? Those questions aren't accusatory. They're analytical, and courts care deeply about timing. They also care about fairness. It's one thing to defend yourself against a claim while evidence is fresh. It's another to do so decades later, when witnesses may no longer be available and records incomplete. This doesn't mean old claims can't succeed, but they face higher scrutiny. Harry's team has tried to counter this by emphasizing power imbalance. That challenging the press earlier may not have felt possible. That awareness of unlawful practices emerged later. Those arguments resonate socially. Legally, they're more delicate, because courts are wary of retroactively expanding liability without clear justification. Throughout this phase of the trial, you could sense the judge weighing these competing realities, not choosing between them, but holding them in tension. And that tension exposes a fundamental vulnerability in the case: its reliance on narrative continuity over evidentiary continuity. Narratives age well. Evidence often doesn't. As testimony continued, the judge's questions began to probe not just what Harry remembers, but how those memories have been shaped. What he knew at the time versus what he believes now. How later revelations about press misconduct elsewhere may have influenced his interpretation of his own experiences. These are not trick questions. They're unavoidable ones. They go to the heart of credibility. Not whether Harry is truthful, but whether his conclusions are reliably anchored to verifiable facts rather than retrospective synthesis. That distinction is subtle, but it's everything. It's also deeply uncomfortable for claimants who feel certain about their experiences, because being asked to disentangle memory from inference can feel like being asked to doubt yourself. Courts don't intend it that way, but the effect is the same. And once that process begins, it's difficult to stop. This is the quiet danger of long-delayed litigation. The longer the gap, the more interpretive work memory has to do, the more vulnerable it becomes to challenge. As this section of the trial unfolded, it became increasingly clear that time was not Harry's ally here. Not because his claims were necessarily wrong, but because proving them now requires an evidentiary precision that may no longer be possible. That realization doesn't arrive all at once. It accumulates. Through questions, through pauses, through the absence of documents everyone wishes existed. And it leaves a residue of uncertainty that no amount of conviction can fully erase. As the judge moved on to the next line of inquiry, the implications of that uncertainty hung in the air. Because if the court ultimately concludes that the passage of time has made these claims too speculative to uphold, the consequences won't be limited to this case. They'll shape how similar claims are viewed in the future. So what happens when certainty starts to wobble? Not collapse, not shatter, just shift slightly off-center. That's often the most dangerous moment in a case like this. Not when something is proven wrong, but when it becomes harder to prove right. As the trial moved forward, the questioning began to narrow in a way that felt almost surgical. Not aggressive, not accusatory, focused. The kind of focus that strips away padding and leaves only the core exposed. This was the phase where the court stopped listening for story and started listening for mechanics. How did this information move? Who had access? What steps were actually required to obtain it? These aren't philosophical questions. They're logistical ones. And logistics are unforgiving. For years, Harry's argument has rested on a kind of intuitive logic. The stories were too precise, too invasive, too well-timed to have been sourced ethically. That intuition is shared by many people who've followed tabloid culture closely. It feels right. But intuition is not a chain of custody. And chain of custody is what the court was now quietly asking for. The judge's questions began circling around process. Not motive. Not morality. Process. What would a journalist have needed to do, step by step, to acquire this information unlawfully? Who would they have needed to contact? How would payment have been arranged? Where would traces of that transaction reasonably appear? Each question had a subtext. If this happened, it left marks. Marks courts expect to see. Harry's team leaned again on the argument that unlawful practices are designed to avoid leaving marks. That illicit methods are concealed by nature. That expecting clean documentation misunderstands how wrongdoing operates. That's not an unreasonable point. But it's also one courts hear frequently and treat cautiously. Because if concealment becomes a blanket explanation, It immunizes claims from verification. It asks the court to accept that absence itself is confirmation. Judges resist that logic for a reason. At this stage, the defense didn't need to prove how every story was sourced. They needed only to demonstrate that lawful explanations were plausible. That journalists could have obtained sensitive information through means that, while uncomfortable, were not illegal. And plausibility is a lower bar than certainty. That asymmetry matters. One side must prove wrongdoing. The other must show it could have happened another way. As that dynamic took hold, the courtroom energy subtly shifted again. Harry's team was still pushing forward, still asserting confidence, but the ground beneath those assertions felt less stable. There was a moment, quiet, almost forgettable, when a question about one particular article revealed how much of the case relies on reconstruction rather than direct linkage. Harry could explain why he believed the information must have been obtained unlawfully. He could describe the personal nature of the detail, but he couldn't identify the specific unlawful act that produced it. That gap lingered. No one commented on it. No one needed to. In court, gaps don't demand attention. They absorb it. Another complication emerged around sourcing culture itself. The defense emphasized something uncomfortable but legally significant: people talk, especially around public figures, staff members, acquaintances, extended networks. Information leaks in ways that feel invasive but aren't illegal. That reality undermines the intuitive leap from intrusion to illegality. Harry's team attempted to counter by arguing that some details were so tightly held that only unlawful access could explain them. The judge's response wasn't to challenge that claim outright, but to ask whether that conclusion excluded all lawful alternatives. That's a devastating question if you can't answer it definitively, because courts don't need to be convinced that unlawful methods were likely. They need to be convinced they were more likely than lawful ones, and that matters on an article-by-article basis. The scale of this challenge became clearer as the court worked through multiple examples. Each one required its own evidentiary support, its own logic, its own rebuttal of alternative explanations. Patterns don't substitute for particulars, and the more the case relied on pattern-based reasoning, the more it risked being seen as generalized rather than specific. This is where the emotional power of Harry's narrative starts to work against him. When someone has been harmed repeatedly, it's natural to connect those experiences into a single story, to see continuity, to interpret each new incident through the lens of the last. But courts are trained to disaggregate. They break stories apart. They isolate events. They ask whether each one, standing alone, meets the legal threshold. That process can feel brutal to claimants. It can feel like minimization, like erasure of the broader harm. But from the court's perspective, it's the only way to avoid sweeping conclusions unsupported by precise proof. Harry's case, at its strongest, is about systemic behavior, about a culture of intrusion that made unlawful methods more likely, even if not visible in every instance. The court's framework, by contrast, is designed to assess individual acts. Those frameworks don't naturally align. And as the questioning continued, the judge's patience with broad framing appeared to thin, not emotionally, but structurally. Each time arguments drifted toward general press behavior, he pulled them back toward the specifics of the defendant and the claims before him. That narrowing effect is exhausting for a case built on breadth. It forces repetition. It exposes weak points. It drains momentum. Another factor quietly complicating things is reputational asymmetry. The publisher is not seeking vindication. They are defending. Their burden is lighter. They don't need to convince the court they behaved impeccably, only that the claimant hasn't met the burden of proving illegality. That defensive posture allows them to remain restrained, to let the claimant do most of the talking, to let the judge ask the hardest questions. And the judge is doing that work, not aggressively, persistently. As this section unfolded, it became apparent that the court was beginning to separate two questions that are often conflated publicly. Did the coverage feel invasive, and was it unlawful? The answer to the first may well be yes. The answer to the second is far less certain. That separation is devastating for a case like this, because public sympathy tends to collapse those questions into one. Courts refuse to. Harry's testimony, when viewed through that lens, becomes less about proving illegality and more about illustrating impact. Impact matters, but only after illegality is established. Without that foundation, impact alone cannot carry the case. This is where the earlier escalation, the fraud allegation, looms again. Because if the court ultimately decides that the defense's explanations are plausible, then accusing them of fraud begins to look disproportionate. Not malicious, but excessive. And courts are deeply sensitive to proportionality. They assess not just what is argued, but how it is argued, whether claims were. One of the most telling dynamics during this phase was how often the judge let arguments run without interruption and then responded with a question that reframed the entire point. Not contradicting it, reframing it. When Harry's team argued that certain information could only have been obtained unlawfully, the judge didn't challenge the conclusion directly. He asked whether the argument allowed for any lawful alternative, even if that alternative was uncomfortable or unflattering. That question does something profound. It shifts the burden from proving wrongdoing to disproving every other possibility. And disproving every other possibility is nearly impossible, especially decades later. Harry's lawyers tried to push back by suggesting that lawful alternatives were speculative, while the inference of wrongdoing was grounded in experience. But experience isn't hierarchical evidence. Courts don't rank it above other forms of explanation. They weigh it alongside them. That's when the tension between conviction and caution became palpable. The stronger the conviction sounded, the more the court seemed to slow down. It's counterintuitive, but experienced judges often become more guarded when arguments feel overconfident. Because overconfidence suggests blind spots. It suggests areas that haven't been stress-tested internally, and judges are trained to find those. Another factor quietly entering the frame was reputational risk. Not for the publisher, but for the court itself. High-profile cases don't just resolve disputes. They set expectations. They signal standards. Nicklin knows that whatever he decides here will be read far beyond the courtroom. It will be cited, interpreted, used as a reference point for future claims involving media, privacy, and historical wrongdoing. That awareness doesn't make him cautious in the sense of avoiding decisions. It makes him cautious in the sense of precision. He needs to be able to explain his reasoning clearly, to justify not just the outcome, but the path taken to reach it. Overstatement complicates that. If the court ultimately rejects parts of Harry's case, it needs to be clear that the rejection is based on evidentiary insufficiency, not dismissal of harm. That distinction is critical and difficult to maintain when rhetoric escalates. This is where the fraud allegation continues to echo. Because accusing a party of fraud doesn't just raise the stakes. It narrows the court's options. Either the accusation is substantiated, or it isn't. There's little room for partial acceptance. Judges are uncomfortable with being forced into binary conclusions prematurely. They prefer layered reasoning, gradations, findings that acknowledge complexity. The more Harry's team insisted on absolutes, the more the court seemed to retreat into nuance. And nuance favors defense. At one point, the questioning drifted toward how the publisher framed its own denials. Whether certain statements were phrased too broadly. Whether there was room for error or oversight without illegality. Harry's team treated those denials as evidence of deception, arguing that such categorical language itself was suspicious. The judge didn't agree or disagree. He asked whether overbroad denials necessarily imply fraud, or whether they could reflect institutional confidence in standard practices. That distinction matters. Institutions often speak in absolutes not because they are hiding wrongdoing, but because they are defending systems rather than individuals. That doesn't make them right, but it complicates accusations of intentional deceit. Again, the court is separating motive from mechanism. Harry's narrative often collapses the two. The judge is carefully prying them apart. As this phase progressed, the courtroom rhythm changed. Fewer sweeping statements. More pauses. Longer silences after answers. The kind of silence that invites reconsideration rather than reaction. And that's when something else became apparent. The emotional energy Harry brings into the room doesn't diminish under scrutiny, but its utility does. Emotion can open doors. It can command attention. It can frame stakes. But once the door is open, emotion doesn't help you navigate the room. Structure does. The court is now deep in the room, and structure is being tested. Harry's team may have believed that pushing harder would compensate for missing pieces. that asserting certainty would project strength. But in this environment, strength looks like restraint. Allowing for doubt doesn't weaken a case in court. Denying it often does. There's a moment in many trials where lawyers realize they are no longer building momentum. They are defending the shape of their argument. That moment doesn't come with an announcement. It arrives quietly, through the realization that every new point must now be justified against earlier overstatements. That's a difficult pivot to make midstream. And it's made harder by the fact that Harry himself remains deeply convinced of his position. That conviction is genuine. It's lived. It's not strategic. But courts don't evaluate sincerity alone. They evaluate alignment between belief and proof. As the judge prepared to move into the next line of inquiry, the sense in the room was no longer that of a claimant pressing an advantage. It was of a claimant navigating resistance. Not overt resistance. Structural resistance. The kind that doesn't shout no. It simply refuses to say yes. And that kind of resistance is far more dangerous. Because once a court stops being persuaded by tone and starts dissecting posture, recovery becomes difficult. Every word is weighed. Every claim measured against its own framing. The next questions would push directly into that territory. Not about what the press did, but about whether Harry's team had overplayed their hand in describing it. And the answers to those questions would determine whether this case continues to narrow or whether it finally begins to slip. So what happens when the court starts looking less at what you're saying and more at how you're saying it? That shift is subtle, almost invisible if you're not watching for it. But once it begins, it's hard to reverse. Up to this point, Harry's case had relied on moral gravity, on the idea that the weight of lived experience, combined with the known history of tabloid excess, would naturally pull the court in one direction. That gravity is real. You can feel it. But courts don't orbit emotion forever. Eventually, they ask whether the force is strong enough to hold. And that's where tone starts to matter. Because as the evidentiary gaps became harder to ignore, the language coming from Harry's side didn't soften. It sharpened. Assertions became more absolute. Framing became more categorical. The defense wasn't just wrong, it was misleading. Not just implausible, but deceptive. In isolation, that kind of language can be persuasive. It signals confidence. It tells a story of certainty. But in a courtroom already showing signs of skepticism, it can trigger a different reaction. Judges don't ask, "Is this forceful?" They ask, "Is this proportionate?" And proportionality is a quiet obsession in law. The court began to focus not only on whether the publisher's explanations were believable, but on whether Harry's team was allowing for uncertainty at all, whether they were acknowledging gray areas or erasing them. Erasure is risky, because gray areas are where courts live. One of the most telling dynamics during this phase was how often the judge let arguments run without interruption and then responded with a question that reframed the entire point. Not contradicting it, reframing it. When Harry's team argued that certain information could only have been obtained unlawfully, the judge didn't challenge the conclusion directly. He asked whether the argument allowed for any lawful alternative, even if that alternative was uncomfortable or unflattering. That question does something profound. It shifts the burden from proving wrongdoing to disproving every other possibility. And disproving every other possibility is nearly impossible, especially decades later. Harry's lawyers tried to push back by suggesting that lawful alternatives were speculative, while the inference of wrongdoing was grounded in experience. But experience isn't hierarchical evidence. Courts don't rank it above other forms of explanation. They weigh it alongside them. That's when the tension between conviction and caution became palpable. The stronger the conviction sounded, the more the court seemed to slow down. It's counterintuitive, but experienced judges often become more guarded when arguments feel overconfident. Because overconfidence suggests blind spots. It suggests areas that haven't been stress-tested internally. And judges are trained to find those. Another factor quietly entering the frame was reputational risk. Not for the publisher, but for the court itself. High-profile cases don't just resolve disputes. They set expectations. They signal standards. Nicklin knows that whatever he decides here will be read far beyond the courtroom. It will be cited, interpreted, used as a reference point for future claims involving media, privacy, and historical wrongdoing. That awareness doesn't make him cautious in the sense of avoiding decisions. It makes him cautious in the sense of precision. He needs to be able to explain his reasoning clearly, to justify not just the outcome, but the path taken to reach it. Overstatement complicates that. If the court ultimately rejects parts of Harry's case, it needs to be clear that the rejection is based on evidentiary insufficiency, not dismissal of harm. That distinction is critical and difficult to maintain when rhetoric escalates. This is where the fraud allegation continues to echo. Because accusing a party of fraud doesn't just raise the stakes. It narrows the court's options. Either the accusation is substantiated, or it isn't. There's little room for partial acceptance. Judges are uncomfortable with being forced into binary conclusions prematurely. They prefer layered reasoning, gradations, findings that acknowledge complexity. The more Harry's team insisted on absolutes, the more the court seemed to retreat into nuance. And nuance favors defense. At one point, the questioning drifted toward how the publisher framed its own denials. Whether certain statements were phrased too broadly, whether there was room for error or oversight without illegality. Harry's team treated those denials as evidence of deception, arguing that such categorical language itself was suspicious. The judge didn't agree or disagree. He asked whether overbroad denials necessarily imply fraud, or whether they could reflect institutional confidence in standard practices. That distinction matters. Institutions often speak in absolutes not because they are hiding wrongdoing, but because they are defending systems rather than individuals. That doesn't make them right, but it complicates accusations of intentional deceit. Again, the court is separating motive from mechanism. Harry's narrative often collapses the two. The judge is carefully prying them apart. As this phase progressed, the courtroom rhythm changed. Fewer sweeping statements, more pauses, longer silences after answers. The kind of silence that invites reconsideration rather than reaction. And that's when something else became apparent. The emotional energy Harry brings into the room doesn't diminish under scrutiny, but its utility does. Emotion can open doors. It can command attention. It can frame stakes. But once the door is open, emotion doesn't help you navigate the room. Structure does. The court is now deep in the room, and structure is being tested. Harry's team may have believed that pushing harder would compensate for missing pieces, that asserting certainty would project strength. But in this environment, strength looks like restraint. Allowing for doubt doesn't weaken a case in court. Denying it often does. There's a moment in many trials where lawyers realize they are no longer building momentum. They are defending the shape of their argument. That moment doesn't come with an announcement. It arrives quietly, through the realization that every new point must now be justified against earlier overstatements. That's a difficult pivot to make midstream. And it's made harder by the fact that Harry himself remains deeply convinced of his position. That conviction is genuine. It's lived. It's not strategic. But courts don't evaluate sincerity alone. They evaluate alignment between belief and proof. As the judge prepared to move into the next line of inquiry, the sense in the room was no longer that of a claimant pressing an advantage. It was of a claimant navigating resistance. Not overt resistance. Structural resistance. The kind that doesn't shout no. It simply refuses to say yes. And that kind of resistance is far more dangerous. Because once a court stops being persuaded by tone and starts dissecting posture, recovery becomes difficult. Every word is weighed. Every claim measured against its own framing. The next questions would push directly into that territory. Not about what the press did, but about whether Harry's team had overplayed their hand in describing it. And the answers to those questions would determine whether this case continues to narrow or whether it finally begins to slip. So what does a judge do when a case starts to feel heavy? Not heavy with evidence, heavy with implication. That's the moment this trial began drifting toward. The point where every new argument carried consequences beyond its immediate claim. Where the court wasn't just weighing facts, but weighing what accepting those facts would require it to say about journalism, history, and proof itself. And judges are acutely aware of that weight. This is where restraint becomes visible, not as hesitation, but as discipline. Judge Nicklin didn't signal alarm. He didn't signal impatience. What he signaled, quietly, was caution. The kind that suggests a mind already projecting forward to the ruling stage, imagining how each thread would need to be tied together coherently. Because rulings don't just answer questions. They explain them. An explanation is where overreach becomes dangerous. At this stage, the court's attention seemed to drift from the individual allegations towards something broader but no less concrete. Precedent. Not in the sense of citing past cases, but in the sense of anticipating future ones. If the court accepts that inference alone can establish unlawful information gathering decades later, what does that mean for every similar claim that follows? If narrative reconstruction becomes sufficient, what standard is left? These aren't abstract worries. They are practical ones. Courts think this way instinctively. Harry's case, intentionally or not, is asking the court to do something expansive. To validate a method of proof that relies on probability, pattern, and personal certainty rather than traceable acts. That's a big ask. It doesn't mean the court won't do it, but it means the court will tread carefully, and skepticism becomes a tool, not a reaction. As questioning continued, the judge began pressing gently on the edges of Harry's legal strategy, not dismantling it, testing it. One line of inquiry focused on whether the case was asking the court to infer illegality from outcome alone. In other words, because the result felt invasive, the means must have been unlawful. It's a seductive logic, and one that resonates deeply with anyone who has felt exposed. But courts are wary of outcome-based reasoning, because lawful conduct can still produce harmful outcomes, and unlawful conduct can sometimes leave little visible trace. Separating those possibilities is the court's job. Harry's team tried to anchor their argument in what they described as inevitability, the idea that no lawful explanation reasonably accounted for the level of intrusion involved. That word again, inevitability. Inevitability is persuasive in speeches. It's less persuasive in judgments. Judges prefer necessity, not that something feels inevitable, but that it was necessary for the alleged wrongdoing to occur in order to produce the result. That's a much higher bar. As the court circled this issue, it became clear that Harry's team was being asked, implicitly, to do something extremely difficult, to prove a negative, to show not only that unlawful methods could have been used, but that lawful methods could not have been. That's a near impossible task, especially after so much time has passed. And courts know that. Which raises an uncomfortable question. Why frame the case this way at all? Why pursue a theory that places such weight on inference rather than focusing narrowly on provable instances? Why escalate language to fraud rather than letting ambiguity speak for itself? Those questions aren't accusations. They're puzzles. And judges solve puzzles by breaking them down. Another shift occurred around this point. A subtle one, but telling. The judge's questions began to reference earlier testimony more explicitly. He was connecting dots, comparing statements, checking consistency. That's often a sign that a judge is moving from information gathering to evaluation. Not conclusion, evaluation. It means the internal framework is taking shape. And within that framework, certain themes were emerging: time, inference, proportionality, and tone. Tone, especially, is beginning to matter more than Harry's team may have anticipated. Because when a court senses that a case has been argued with maximal force from the outset, it begins to wonder what room remains for adjustment, for concession, for nuance. Concessions don't weaken a case in court. They strengthen it. They signal realism. They show the court you understand its concerns. But Harry's legal strategy has left little room for concession. Everything has been framed as clear, systemic, and deliberate. The press didn't overstep occasionally. It operated unlawfully. The defense isn't mistaken. It's fraudulent. Those positions leave no middle ground. And courts almost always occupy the middle ground. That's where the danger lies. Because if the judge ultimately believes that some intrusion occurred, but not enough to meet the legal threshold for unlawful activity, or not enough to support allegations of fraud, the ruling could be framed as a rejection of overreach rather than a validation of harm. That distinction matters enormously for Harry. A loss framed as insufficient proof is one thing. A loss framed as exaggerated accusation is another. The latter carries reputational consequences that extend beyond this case. As the hearing continued, there was a growing sense that the judge was calibrating not just whether Harry's claims were persuasive, but whether they were responsibly presented. Responsibility is an underappreciated concept in litigation. It's not just about ethics. It's about trust. Courts trust lawyers to frame disputes accurately, proportionately, and with respect for uncertainty. When that trust erodes, even slightly, everything becomes harder. Harry's team is operating under intense pressure. They know the public stakes. They know the symbolic weight of this fight. They know that anything less than a strong stance could be interpreted as retreat. But courts don't reward symbolic battles. They resolve disputes. And dispute resolution requires flexibility. One of the most revealing moments came when the judge asked a question that, on the surface, seemed minor, almost procedural, but carried significant implications. He asked whether the case would look different if certain allegati